submits that in both the Kenyan case and the case at bar, there was a delay in the discharge of the constitutional duty imposed on the president. In the context of Article 127, counsel for the applicant argues that the president is not expected to delay consultation with the leader of the opposition for the substantive appointment of Chancellor and Chief Justice, even where no time limit has been set for such an engagement. In such circumstances, the president is enjoined to act with all convenient speed. In this regard, the court's attention was averted to Article 232(9) of the Constitution, which provides that it is the Interpretation and General Clauses Act which should be applied for the purposes of interpreting the Constitution. Section 9 of 39 of that Act stipulates that where in any written law, no time limit is ascribed or allowed within which anything shall be done, such things shall be done with all convenient speed and as often as the prescribed occasion arises. The applicant submits that His Excellency has failed to act with all convenient speed to engage with the leader of the opposition to obtain his agreement for the substantive appointment to be made under Article 127(1). The delay and or refusal by the president to commence the process required by Article 127 for more than 2 years is unreasonable and in breach of the duty imposed by the Constitution. Senior counsel for the respondent has submitted that the president is committed to complying with all his constitutional obligations and duties, and is on record as saying that he's prepared to make the appointments to the offices of Chancellor and Chief Justice. Counsel urges the court to look at the president's duty to comply with Article 127(1) of the Constitution in the context of the political travails which surrounded the office of the leader of the opposition since His Excellency has taken office. He argues that the Adrian Njenga case is distinguishable from the matter, noting that in the Kenyan case, the only role of the President of Kenya was to formally appoint the judges. However, in this case, appointments to the offices of Chancellor and Chief Justice requires the agreement of the leader of the opposition. This agreement is a necessary precondition to any such appointment. Senior counsel argues further that the successive leaders of the opposition have contributed to the delay in commencing the process set out in Article 127. Having regard to the doctrine of separation of powers, he urges the court to treat very delicately with what has been a historical impasse, which according to him is close to enjoying its first resolution. Counsel submitted that it would be prudent for the court to exercise judicial restraint and allow the two constitutional actors to perform their constitutional duties, since both parties have expressed a commitment to comply with Article 127 of the Constitution. Counsel relied on the case of Christopher Ram against the Attorney General of CCJ 2019 CCJ decision, in which a CCJ stated that it would not therefore be right for the court, by the issuance of coercive orders or detailed directives, to presume to instruct these bodies on how they must act and thereby preempt the performance by them of their constitutional responsibilities. It is not, for example, the role of the court to lay down timelines and deadlines that, in principle, are the preserve of political actors guided by the constitutional imperatives. The court must assume that these bodies and personages will exercise their responsibilities with integrity and in keeping with the unambiguous provisions of the Constitution. Senior counsel for the respondent argues that following the CCJ's admonition in Christopher Ram, the court in like manner ought not to direct how or when the president and the leader of the opposition should execute their constitutional duty. Counsel argues further that Article 127(1) of the Constitution vests the power to appoint the Chancellor and Chief Justice in the president after obtaining the agreement of the leader of the opposition. As such, it is the president who must initiate this process. He submits that given the history of Article 127(1) and the marked absence of an agreement between the president and the leader of the opposition since its amendment in 2001, and the short period of time the current president has had to comply with its provisions, that the court ought to refuse the relief sought. Having regard to the contents of the fixed date application and the relief sought, as well as the affidavit and defense file, this court considers that the only issue to be determined is whether, in the circumstances of the instant case, the delay in initiating the process for the the appointment of a substantive Chancellor and Chief Justice by the President under Article 127(1) is a breach of the Constitution, or whether such a delay amounts to gross dereliction and abdication of duty of the President under the Constitution. It cannot be disputed that to date there has been no engagement between the President and Mr. Norton, the current leader of the opposition, regarding the substantive appointments of Chancellor and Chief Justice. This is not a fact to this. Such appointments are to be made under Article 127 of the Constitution, and I have set out what the provisions of that article says. It is apparent upon reading of Article 127(1) that the Constitution imposes a mandatory obligation on the President and the Leader of the Opposition to come to an agreement on the individuals to be appointed substantively as Chancellor and Chief Justice. The utilization of the word shall in the article shows sufficient certainty of this. Former President of the CCJ, Sir Dennis Byron, in his address to the Guyana Bar Association dated in 2017, expressed some very strong views on our historic impasse. He said this: "The Constitution is the supreme law of the land, and no authority is above it. It is the duty of the court to interpret it and ensure that its provisions are applied. The delay in complying with Section 127(1) of the Constitution has long reached the level of justiciability, and the most appropriate authority for resolving this situation is the court system. Section 127(1) ascribes an obligation to the President and the Leader of the Opposition that is mandatory in nature and not discretionary. Any failure in fulfilling this obligation must therefore be regarded as a breach of the Constitution. Article 127(2) of the Constitution makes provision for when the offices of Chancellor and Chief Justice are vacant, or the persons holding those offices are, for any of the stated reasons, unable to perform their functions. Then those functions shall be performed by such order of the judges as shall be appointed by the President after meaningful consultation with the Leader of the Opposition. It is under this article that the seemingly endless acting appointments of Chancellor and Chief Justice have been made. In this regard, this court is of the view that despite the existence of Article 127(2), it could not have been the intention of the framers of the Constitution that Article 127(1) would not be complied with for decades, resulting in perpetual acting appointments to these substantive posts. Acting appointments by their very nature suggest that they are for short term and made on a transient basis. Article 127(2) is not and ought not to be used as a lacuna or loophole through which a President and a Leader of the Opposition can abdicate his or her mandatory constitutional obligation under Article 127(1). This court is of the firm belief that Article 127(1) of the Constitution was fashioned by the framers with the aim of consensus building and political comity. So much so that the bar was raised for these constitutional appointments from mere consultation with the Leader of the Opposition to agreement of the Leader of the Opposition. This is recognition that all political stakeholders should have a part to play in the ultimate selection of these important constitutional posts. Therefore, the Constitution must have also intended that the President and the Leader of the Opposition would act with abundant good faith in the discharge of their duty under Article 127. It must have also been envisaged that some level of expediency in filling these important constitutional offices would be exercised to ensure the competent functioning of the judicial arm of the state. The absence of substantive appointments to the offices of Chancellor and Chief Justice, particularly for the protracted length of time that we have experienced in Guyana, fails to insulate the judiciary from attacks on its independence as provided for in Article 122(a) of the Constitution, which threatens the very fabric of our thriving democracy. In this regard, Justice Saunders, along with Dr. R. Volkan and Tracy Robinson, in their treatise, Fundamentals of Caribbean Constitutional Law, at page 372, have this to say. Just give me 1 second, sorry. Yes, have this to say. The requirement in Guyana that the president and the leader of the opposition must agree on the selection of the chancellor and chief justice has been a recipe for paralysis and led to the insecure and long-term acting appointments for the most senior judges, which is contrary to judicial independence. The authors also mentioned the decision of Justice William Ramlal in Committee for the Defense of the Constitution against the Attorney General, a case that concerned the constitutionality of the appointment of Justice Singh to act as Chancellor while also functioning as the Chief Justice. Justice Ramlal, at page 30 of his judgment, said that the failure to act by the parties named in Article 127(1) of the Constitution, who have the constitutional responsibility for the appointment of the Chancellor for such a prolonged period of time, flies in the face of Article 122A of the Constitution. Article 122A speaks to the independence of the judiciary and provides that all courts and all persons presiding over the courts shall exercise their functions independently of the control and direction of any other person or authority, and shall be free and independent from political, executive, and any other form of direction and control. Still speaking about the dicta of Justice Ramlal in Committee for the Defense of the Constitution, Justice Saunders and company said further at page 373, arguably, even without a time limit imposed by the Constitution, the judge could have grounded his decision on judicial independence, since an acting appointment over 2 years was inimical to the good governance and the rule of law. Since 2005, neither the positions of Chief Justice or Chancellor has been confirmed, and they remain acting appointments. A most unsatisfactory situation given the seminal litigation that comes before them, in which the state is a litigant and has a strong vested interest in the outcome. To date, regrettably, Article 127(1) of the Constitution has never been complied with since its amendment in 2001. This fact tells its own story. The respondent has laid out the circumstances which have impacted the initiation of the process towards obtaining the agreement of the leader of the opposition for substantive appointments to be made to the offices of Chancellor and Chief Justice. This has not been refuted by the applicant, so that this court, in making a determination on the issue raised in the case, must take these factors into account. The applicant has not denied that before the appointment of Mr. Norton as the leader of the opposition, his successor refused to recognize His Excellency the President and his government as legitimate. In those circumstances, this court cannot find fault in the submission by counsel for the respondent that so long as that position obtained, how then could there be an engagement by the President with the leader of the opposition? A delay occasioned by these circumstances appear reasonable and rational. The Honorable Chief Justice acting in the case of Aubrey Norton against the Attorney General referred at paragraph 63 to the dicta of Justice Jamadar in the CCJ case of Air Services Limited against the Attorney General. Chief Justice George is reported as saying, while Justice Jamadar observed that the onus is on the state and the public authorities to initiate the consultation process and ensure that its requirements are satisfactorily met, he further observed that the consultative process requires active engagement, mutuality, sincere receptivity, and genuine openness to correctly understand and appreciate the recommendations. As such, though the onus is primarily on the President to initiate the consultation process and to ensure requirements as set out in Article 232 are met, there is a corresponding onus on the party being consulted to reciprocate. As we say colloquially, one hand cannot clap. Similarly, in the instant case, although the onus is on the President to initiate the consultative process for appointments under Article 127(1), since it is in him that the power to appoint resides. From the period August 2020, when he took office, to April 2021, when Mr. Norton was appointed, the then leader of the opposition, when Mr. Norton was appointed the leader of the opposition, there was no reciprocal party with whom he could have engaged, given the refusal of the then leader of the opposition to engage. There was no active engagement, mutuality, and sincere receptivity on the part of the then leader of the opposition to partake in such a process. It appears from the evidence before the court that it was only after Mr. Norton was appointed as leader of the opposition that any interest in consulting with the president was demonstrated. It was shortly after Mr. Norton's appointment that there were correspondences back and forth between himself and Mr. Chair regarding the discharge of his constitutional duties to consult on certain appointments. The last letter in the series is a letter dated 7th June 2022, written to Mr. Scherer by Mr. Ford, who signed as representative of the leader of the opposition. In that letter, Mr. Ford identified two specific persons for appointment to the offices of Chancellor and Chief Justice and signaled the leader of the opposition's unconditional agreement with the substantive appointment of the named persons. It was a few weeks after the date of that letter that the instant proceedings were instituted. The applicant has contended that over 2 years has elapsed without the president making an effort to commence the process required to comply with Article 127.1, calling it a gross dereliction and abdication of duty. However, Article 127.1 of the Constitution does not prescribe a time limit within which the president and the leader of the opposition are to act to obtain an agreement. Justice Ramlal, in the Committee of Defense of the Constitution, has said at pages 28 and 29 of his judgment that, in light of the declaration sought by the plaintiff, I have to return to Article 127 of the Constitution. The affidavit evidence of both parties establishes conclusively that His Excellency the President and the Leader of the Opposition have not reached an agreement as to who is to be appointed to hold the office of Chancellor pursuant to Article 127.1 of the Constitution. This therefore means that Article 127.2 of the Constitution comes into operation, and it is herein constitutionally provided inter alia for a person to be appointed to perform the functions of the office of Chief Justice after meaningful consultation with the leader of the opposition. This article does not place any restriction as to the time limit within which such a person is to perform the functions of the office of Chancellor, nor does it place This article does not place any restriction as to the time limit within which such a person is to perform the functions of office of Chancellor, nor does it place any time limit for agreement or consultation. The absence of such time strictures in Article 127 of the Constitution ought, in this court's view, to enjoin the President and the Leader of the Opposition to act with all convenient speed to make these substantive appointments, given their fundamental importance to the functioning of an equally important arm of the state. The applicability of Section 39 of the Interpretation of General Clauses Act to the interpretation of the Constitution has been provided for in the Constitution itself. As to what would be considered with all convenient speed must of necessity turn on the circumstances of each case. In the case of Mahabir Anil Nandalar against the Minister of Legal Affairs, the Honorable Chief Justice, in considering the duty of the Minister to bring the Judicial Review Act into operation, touched on the utility of Section 39 of the Interpretation of General Clauses Act, the circumstances where no time limit is prescribed in statute. She said at page 4, that in such a case, Section 39 fills that gap by stating that it shall be done with all convenient speed. As to what this term means, the learned Chief Justice referred to the case of Stephen Edwards and the Attorney General, where the CCJ noted at paragraph 22 of their judgment that Section 39 is a potent reminder of the need for expedition in all matters of the Constitution. Her Honor, after considering several authorities on the subject, concluded at page 6 that though the phrase all convenient speed does not impose a specific time limit, courts apply it by considering whether the acts or matters or issues to which it applies have been done expeditiously and without unreasonable delay in the particular circumstances. Now, the appointment of a substantive Chancellor and Chief Justice is mandated by the Constitution to be done by the President, acting after having obtained agreement of the Leader of the Opposition. The named parties have a mandatory obligation to comply with the provisions of the Constitution to make these appointments. This necessarily requires active engagement, mutuality, and sincere receptivity by the constitutional actors. While the Constitution does not give time limits as to when this process is to begin or end, it is expected that, even without the court's intervention, the President and the Leader of the Opposition would act with some expedition to bring this impasse to a swift end. In the matter now under consideration, this court finds that given the particular circumstances attendant to this case, the delay in initiating the process for the substantive appointment of the Chancellor and Chief Justice by His Excellency the President under Article 127(1) is not a breach of the Constitution. Further, this court is unable to find that such a delay meets the threshold of gross dereliction of constitutional duty on the part of the President. The period referred to by the applicant and upon which his claim is based is stated to be from August 2020 to April 2022. However, from the evidence put before the court, for much, if not all of that time, the Leader of the Opposition was not prepared to enter into any engagement regarding any appointments. There is no doubt in this court's mind, and there was no evidence which persuades this court otherwise, that the stance taken by the then Leader of the Opposition contributed to the delay, which is now being complained of by the applicant, who himself is a member of the party in opposition. The evidence suggests that it was only from April 2022 that the Leader of the Opposition indicated his interest in consulting. Therefore, by all accounts, the way is now clear for this engagement to commence, and no further delay or excuses ought to be countenanced. The respondent has said that the President has repeatedly stated his intention and commitment to comply with all his duties under the Constitution. In this court's view, there would be no better way that the President can demonstrate this unassailable devotion and commitment to his duties than by acting with alacrity to initiate the process for the eventual substantive appointment of Chancellor and Chief Justice. Even though this court adopts the view of the CCJ and Christopher Ram that it would not be appropriate for the court to dictate timelines and dates by which the constitutional actors must engage, the sordid history of non-compliance with Article 127(1) of the Constitution dictates that this issue be given the highest priority by those with the constitutional responsibility to ensure that the substantive appointments are made. For too long, Guyana has been without substantive office holders for the two top positions in the judicial arm of the state, a situation which continues to be untenable and unacceptable to the citizenry and inimical to the independence of the judiciary that the supreme law of the land provides for. Any further delay in commencing this process should be eschewed so that this significant blot on the otherwise impressive Guyanese legal and judicial landscape is not perpetuated further. Having considered the fixed date application together with the affidavit in defense and the written as well as oral submissions by counsel for the parties, this court holds that in the circumstances of the instant case, the delay in initiating the process for the substantive appointment of Chancellor and Chief Justice by His Excellency under 127(1) between the period August 2020 and April 2022 is not a breach of the Constitution, nor is it a gross dereliction of constitutional duty on the part of the President. This court also holds that the position taken by the Leader of the Opposition during the stated period directly contributed to the delay in the commencement of engagements, the aim of which is to bring finality to the matter of the substantive appointments of the Chancellor and Chief Justice. The findings of the court notwithstanding, and having regard to the import and the constitutional significance of the matters raised in these proceedings, the following declarations are made. A declaration that Article 127(1) of the Constitution creates a mandatory constitutional duty and obligation on the part of the President and the Leader of the Opposition to comply with its provisions. A declaration that for as long as there are no substantive appointments to the offices of Chancellor and Chief Justice under Article 127(1) of the Constitution, the President and the Leader of the Opposition are under a continuous mandatory constitutional duty and obligation to engage in a process which results in the compliance with Article 127(1) of the Constitution. Declaration that notwithstanding that Article 127(1) of the Constitution does not set any timelines for compliance with its provisions, the duty imposed by the constitutional actors by Article 127(1) must be discharged with all convenient speed. A declaration that any protracted or further delay in complying with Article 127(1) of the Constitution is and would be inimical to the independence of the judiciary as set out in Article 122A of the Constitution. In light of the public interest nature of the matters considered in this fixed date application, it is ordered that each party shall bear his or her own legal costs. That is the decision of the court, and I undertake to have this sent out, as I said, within another hours or two. Thank you.
Thank you very much, Your Honor.
Thank you very much, Your Honor.
You may all take your leave.